I'm Michael Hackard with Hackard Law. If you've been left out of a trust, if your inheritance was suddenly reduced, if someone else, maybe a new spouse, a caregiver, or a sibling, ended up with everything, you might be what California law recognizes as a disadvantaged beneficiary. This isn't just about disappointment, it's about injustice. And in many cases, it's about the law being broken. At Hackard Law, we represent clients across California who believe they've been treated unfairly in trusts or estates. And today, I want to walk you through what it means to be a disadvantaged beneficiary and what you can do to fight back. Let's start with the basics. A disadvantaged beneficiary is someone who was originally included in a trust, but later removed or reduced, excluded under suspicious circumstances, or given significantly less than others, often while someone close to the decedent gains disproportionately. So, how does this happen? Scenario 1. Sudden trust changes. Was the trust changed at the last minute? Was your loved one ill, isolated, or mentally declining when those changes happened? That's a red flag. If you were in the trust for years and suddenly cut out near the end, you may be a victim of undue influence. Scenario 2. Favoritism toward a caregiver or new spouse. Did someone new come into your loved one's life, then take over everything? It happens more often than you think. A romantic partner, live-in caregiver, or new spouse can manipulate a vulnerable person, redirecting the entire estate in their favor. Scenario 3. Unequal treatment among siblings. It's legal to treat heirs differently, but if one sibling got everything and also controlled your parents' finances, medical care, or legal documents, it may be a breach of fiduciary duty or undue influence. Scenario 4. Missing or undisclosed assets. Did the estate seem smaller than expected? Were family businesses, real estate, or valuables missing from the trust? That could point to concealment, fraud, or self-dealing by the trustee. And that's actionable. If you're seeing any of these signs, don't dismiss them as family drama. They may be evidence of serious legal violations. So, what are your rights? You have the right to an accurate accounting. Trustees must be transparent. If they're evasive, vague, or outright refuse to share records, we can petition the court to compel full disclosure. You have the right to challenge a trust. If it was changed under pressure, signed by someone lacking capacity, or manipulated through fraud, you can contest its validity in court. You have the right to remove a trustee. If the trustee is biased, self-dealing, or negligent, the court can remove and replace them and even order repayment of lost assets. You have the right to a fair distribution. Even valid trusts can be reformed if they violate public policy or result from exploitation. At Hackard Law, we don't just talk about justice, we pursue it. Our team builds strong evidence using medical records, financials, and witness testimony, collaborates with forensic accountants and private investigators, files fast and strategic court actions to freeze, recover, and redistribute assets. And we do it all on a contingency fee basis. You don't pay us unless we recover for you. If you think you've been wrong, the most important step is to act quickly. Start by gathering documents, emails, old wills, financial records, anything that helps establish what your loved one truly intended. Watch for red flags, secrecy, sudden changes, evasive trustees, or new beneficiaries who weren't part of the family until recently. And finally, consult an estate litigation attorney. These cases are complex and timing matters. I'm Michael Hackard. If you believe you're a disadvantaged beneficiary, you don't have to stay silent. You have rights, and we can help you protect them. Contact Hackard Law today for a confidential consultation. Let's make things right.